Good afternoon. Today is Tuesday, August 20th, 2019, and this is the second hearing this month for the City of Tempe Hearing Officer. My name is Vanessa McDonald, and I am the Hearing Officer, and joining me today from Community Development are Shelby Meyer and Drew Yoakum. I'm going to read something into the record, and then we can go ahead and get started on our brief agenda this afternoon. The City of Tempe Hearing Officer is authorized by Arizona Revised Statutes and the City of Tempe Zoning and Development Code. The hearing officer has the duty to carry out both the provisions and the intent of the Zoning and Development Code and the Tempe City Code. The hearing officer is granted the authority through ZDC Section 6-310 to conduct public hearings to decide upon the abatement of code violations occurring on properties within the city. Code violations include, but aren't limited to, deteriorated landscaping, inoperable vehicles, deteriorated structures, storage of junk or refuse, or deteriorated swimming pools. And abatement actions are brought to the hearing officer by the city's Code Compliance Division, typically after numerous attempts at contacting the property owner to obtain voluntary compliance with the code. And the hearing officer can issue an order directing the owner, occupant, rental agent, property manager, or other responsible person to abate a code violation, or may authorize the city to abate the condition giving rise to the violation. And the cost of the abatement is the responsibility of the owner of the property where the violation occurred and may be collected as an assessment against the property found to be in violation. On today's agenda, we just have two items. We have a set of minutes and a single property abatement. Any property owner who's aggrieved by a decision of the hearing officer may file an appeal within 14 calendar days after the hearing officer has made a decision. As such, the deadline for appealing any decision rendered today is 3 p.m. on September 3rd, 2019. And abatement appeals are heard by the Board of Adjustment, after which they may also be appealed to Superior Court. The property owner has 14 days to either file an appeal or bring the property into code compliance. And if neither of these things happen by this date, this September 3rd date, the property will be abated by the city. As I mentioned, we have two items on our agenda. The first is a set of minutes from August 6th. 2019, and I had a chance to review those minutes in the packet that I received, and I believe that they reflect what took place at that hearing. So I'm going to go ahead and approve the minutes for August 6th, 2019. The next item on our agenda is a request for approval to abate public nuisance items at the Storm property located at 1105 West Elna Ray Street. The applicant is the City of Tempe Code Compliance, and Andre Lara Reyes is here this afternoon.
Good evening, Andres Lara Reyes, City of Tempe Code Compliance Division. I'm here to request a 180-day open abatement of the property at 1105 West Elna Ray Street in Tempe, Arizona 85281. This is for the owner, Storm Family Trust, in care of Joe and Susan Storm. Original complaint to our office came in on March 5th, 2019 for trash and debris, furniture crate buckets and jug containers in the carport area, and also for grass and weeds over the gravel in the front yard area. I sent out a couple of notices and also posted notices to the property, but as of this morning, and we got some pictures, there were significant improvements to the property. Some painting going on in the front elevation of the property. Most of the carport is cleaned up. Reviewed the case with the office administrator, and it was determined that the grass and weeds that remain over towards the west of the front yard area remains in violation. So that's why I'm requesting this open abatement in the event that it doesn't been taken care of in the next 2 weeks.
Okay. Thank you. Yeah, I didn't drive over the weekend. I drove by the property last Thursday and observed a little bit, but again, not to the complete extent, I think. I think some of this maybe took place over the weekend.
Yeah.
Yeah, I'll call on you next. The procedure is we hear from staff and then I call to the public. So you'll be invited to come up to the podium.
Like I say, most of it is done. It's probably maybe 30% still in violation for the grass and weeds over gravel. So that's our concern, that it'll be taken care of in the next 2 weeks. If it doesn't, then we can abate the property.
Okay,
Okay, thank you.
thank you. If you'd like to come up, sir, and I'll have you state your name and address for the public record. I have it here, but this is being televised.
My name is Daryl Steele, and I'm here representing 1105 West Elmore Street.
Okay, thank you. I noticed in the communications they all went to Susan Storm. What is the relationship?
My deceased grandmother.
Okay.
Can we put those photos back up?
Yeah.
Where do you see any weeds in that photo?
Okay. This is not a forum where you ask.
He stated that 30% of the yard still had weeds, and I cannot see any weeds in any of his photos. By the picture of his photos, and you stated you went there by the Thursday. I know the house was painted Friday, and the yard workers were out there Saturday and Sunday because they couldn't be the same day there as the painters, and they're supposed to be doing the trim work for the painting today. Because we wanted to make sure everything was completely absolved, but you can't really do that stuff when it's 130 degrees outside because the paint doesn't dry right and a bunch of issues. So my understanding is I'm looking at these pictures and I don't see any weeds. And I've walked that property. There weren't any weeds before I came here today. And his pictures show no weeds. So that would mean that there's no right for abatement. His pit photos don't show any of the stuff on the carport that he was complaining about because it's all gone. So I would, under my understanding, since there is no evidence here to show need for abatement, that we would not be having an abatement. So I'm asking, does he have any photos that show the things he's talking about, or if there's any evidence to show those things still exist?
Well, first of all, this is not a court of law. We don't follow evidentiary rules as you would in a judiciary hearing. You know, it's a city process. And as I explained at the beginning of the hearing, one of the good things about the abatement process is it's not immediate. You know, it doesn't take place tomorrow. It takes place 14 days after I render an opinion.
Wait.
So let me finish. So if what you're telling me is the property has been cleaned up to code compliance standards, and you know we can't be out there every minute of every day, then what happens is they would go out there, re-inspect the property. If it's been cleaned up to their satisfaction, then the abatement goes away, and there's no remedial action taken by the city.
Here's my problem with that. The last time they abated the property, I found out it cost $300 to file an appeal. Ridiculously cost preventative to file an appeal based off your decision today if you find something that I don't agree with. So I would need to solve any issues today because an appeal is punitive, extremely punitive. Okay, beyond that, they had an abatement last year, and this gentleman came out to the property with a crew and performed work where he signed off that half the things on his current complaint were not violations under penalty of perjury, that he had no issue with them and they did not need to be corrected because they existed at the time he was on the property last performing an abatement. He then charged the property for something like 4 hours work for the 5 members of the crew that were out there, even though they were only on the property for an hour because they had minimums. And I was told by a supervisor, that's completely against the policy of the abatements and not how it should have been built. And we never received a copy of the bill of the abatement. Okay, so we don't even know what was billed to the property because we never received due process on the last abatement that happened. So I have this problem where in the past when an abatement was issued and I had issue with it, I could not appeal it because it was punitive. And when they did come out to perform an abatement, they did not do appropriate work. And through his own signature, he stated that the items that were currently in the complaint were not an issue and did not need to be abated. So I don't understand why the city code enforcement is saying, on the one hand, these are not problems and do not need to be fixed while we're here. And on the other hand, coming back to me a year later and saying, oh, those things we didn't fix, we think they need to be fixed. Beyond that, this gentleman showed up on the property last November and refused to leave. A sergeant for the Tempe Police Department came out to the property, explained to him that he was unlawfully trespassing and had to go. I, at the time, explained to him that he was being civilly trespassed, that he was no longer allowed back on the property and should not ever come back. He had no legal right to be there, squatted on the property for several hours, and hurled insults at me and threatened to arrest me if I didn't come out of my house. So there's issues with this whole entire process. You can see, as a citizen of the city of Tempe, I have complaints that it seems to me that I'm being railroaded for things that don't exist because we haven't seen any pictures that show that there's any current issues. And then after I'm railroaded, I really don't have anything to do but go along with the process because it's too punitive for me to try and get an appeal or do anything beyond that. Do you understand my viewpoint?
I understand your frustration, and I'll just tell you that what happened last year is not part of this proceeding today. It's not cumulative in nature. It is of interest to me that it's been multiple abatements, but truly it's neither here nor there. We're here today for what's occurring on the property right now. So that's all I'm looking at. I'm not looking at past history. And moreover, as I explained, your 2-week window is not just to appeal. That's one avenue. Your other appeal is to clean up the property to the satisfaction of code inspection. If that's the way it is right now and they go out and re-inspect tomorrow, then there's no harm, no foul. What is the harm to you at that point? The abatement will go away.
If he doesn't submit photos to here to show me what he's complaining about, I have no clue what he's talking about to be able to go fix it. So if you approve this today, I don't know what to go fix because as far as I can tell, it's all been done. And he's saying it hasn't, but he hasn't submitted any photos to the contrary.
Madam Hearing Officer, can I propose
to
see the photos?
Yeah,
Bring them to you.
you can bring the photos, but also I rely on my own observations. I don't just take the packet because I know things can and do change from the time I get the packet, probably 10 days ago to today. I try and do it, typically the morning of or the Sunday before, but I was out of town this weekend. That's why I went by on Thursday. But that's why I said I was there on Thursday and things often change at the last minute.
Then because a current inspection hasn't been done, I would ask that any abatement order be postponed until a future date for a future hearing.
So this is dated today at 10:28, and I mean, I can see, and I'll hand these to you after there's, some dead weeds in the gravel as you're looking at the property from the street on the right of the property.
So the grass is allowed to be up to, I believe, 2 inches by city code compliance. So if you're talking specifically, this is the corner of the house that's in question. That's the grass that is less than a ½ inch in height because it grows through the rocks. You can't pull it through the clay. Okay, like I'm in the process of removing all the gravel in the front house, but we're talking 3 or 4 months for me to remove a literal 1.5 tons of gravel to get this back to a dirt lot.
Have you sprayed it with spray?
It's all dead. You see it's all dead, right? Like all the spray does is kill it. I mean, like it's not growing. It's not.
Well, do I think it's minimal? Yes. Do I think it can be accomplished in a couple of weeks? I believe so.
The code allows for up to 2 inches of grass. Is that correct? Okay. Where does the code say that the grass is not allowed? There's no decomposed granite.
That's exactly what you have.
That's gravel.
I really don't know what I'm supposed to do in this situation because it's been hit with a weed eater and everything. And I literally have got like 300 sandbags at my house to fill with the gravel to remove the gravel. But it's going to take me a good month and a half to get that gravel out of there. And I really don't need the city coming out to abate while I'm trying to have the gravel removed.
Well, I think, and you can correct me if I'm wrong, I think the city wants to see what we would call adequate progress towards remediation.
He stated that over 70% of all the work has been performed. And as far as I can tell, the only thing we're complaining about is this much grass that sits this high in the yard that's not even barely visible from the street because you can't barely see it in his photos.
So, okay, here's what I'm inclined to do, and you know what I have the authority to do, and I know you're not going to like it, but this to me looks like it can be remediated within 2 weeks. And I would encourage you to work. I know, you have
The letter the state sent me said that I would have 30 days from this hearing,
30 days from what?
from today,
To,
to do the remediation.
is that? Well, this is dated July 10th.
Mm-hmm.
So what it's saying is if the violations have not been corrected within 30 days, not of this hearing, within 30 days of July 10th.
It says 30 days of the hearing. It says a hearing will be performed, and at that time to be assessed that the remediation to be created within 30 days of the hearing if the repairs are not completed.
I see two 30-day references, neither of which have to do with this hearing. The other is you have 30 days after receipt of this letter to abate if the violations have not been corrected within 30 days.
If you give 2 weeks, that wouldn't be 30 days.
So you've already had nearly 30 or over 30 days from the date of this notice. So 45, maybe 50 days from the date of this notice. So that deadline was disregarded. So now we're here. And then from today, you would have another 2 weeks. So that would take you to like 60 days from the date of this notice, which I'm not going to ask what happened after July 10th, after, from that time till now. Other than that, I believe it's completely reasonable to think that, as you characterize it, this minimal amount of deteriorated landscape can be cleaned up within a 2-week period.
I think that his date at the top of that letter is possibly when he mailed it. I don't think that's the date that it was actually issued to the house because I haven't been getting the ones that he's been mailing. And that was the one that was stapled to the front door. So I don't know.
Do you live at 1105 West El Noray?
Yes and
where you're
no.
living?
No.
You do not. Because that's where the notices have been mailed. Yeah. So let's say it was mailed on the 10th, the property would have gotten it on the 10th. Nevertheless, you received it because it was stapled to the front door. That's why we make multiple attempts at contacting the property owner, because we know that in trust situations and with deceased owners, oftentimes it's a challenge to notify.
And he was notified last year of the address of the property owner. He still has refused to mail anything to the address of the property owner. I don't know why. The court last time asked him, or you guys last time asked him to actually notify the property owner, and he's just chosen not to. I really don't know why.
I believe it's who the Maricopa County Assessor parcel, those notices, who pays the taxes and where those tax bills are sent, and clearly they're being paid. Someone at this address is getting the mail if the taxes are being paid on the property. So the city's assumption is that's a good and valid address.
The U.S. government's paid the last 4 years of taxes.
Excuse me?
The U.S. government's paid the last 4 years of taxes. NOVAD through Fannie Mae and Freddie Mac has been paying the taxes. not going from the property.
Okay. In any event, I believe that we agree on one thing and that there are minimal improvements that need to be made to the property. And for that reason, we're arriving at different conclusions, but because I feel that they are minimal and they can be taken care of and cleaned up within the next 14 days, I'm going to go ahead and abate and approve the abatement so that you will clean them up within the next 14 days. And then if you don't, the city will go out and they will abate the property for you.
Can we hold that abatement until the next hearing? And if I show up at the next hearing with proof that it's been done, then we don't do that? And if it's been done by then, we don't issue an abatement?
It's the same effect. The next hearing is 2 weeks from today. So why would you want to show up here and prove that you've cleaned the property where you can just clean the property and not show up? It's the same
Because
result.
I don't want a 6-month abatement issued against the property.
Is it your intent to let it go back to a state of disrepair
No.
after you clean it up this time? Then what's the downside of a 6-month abatement?
The downside is that I have to deal with the notifications again. And my understanding from what I was told by the abatement company is they're not allowed to issue again unless they receive a complaint from one of my neighbors. So it's not just whether or not it's open, it's beyond just whether or not the property falls into disrepair.
Well, okay, but I see it, the 180-day open abatement is the city's assurance that you will not let it fall back into a state of disrepair, and we won't have to re-engage the neighbors after a 30-day abatement would occur. Then you could just let the grass grow, you could do whatever we wanted, and we would have to go through the entire process all over again.
Seems
And I
fair.
think,
If I completed my end, why should the city not have to go
but
through
you
their
haven't
process again?
completed your end yet. So you do it in 2 weeks and you maintain the property for the next 6 months and it goes away. I mean, it's an easy remedy. Instead of arguing about it, just go clean the property and keep it clean.
I plan on getting
for
it
6
done
months.
today. If you guys will still be here in
Fabulous.
4 hours before the hearing ends, I'd be happy to come back with photos to show that that grass has been removed
That's not going
today.
to happen. Just go clean the property as you say you intend to do and keep it clean for the next 6 months and nothing will happen on your property other than you'll have a good looking clean property.
There are other legal ramifications to having an open abatement.
Such as?
There's legal ramifications to, I don't know what it's called.
Well, I feel like the city's on solid ground. I think that I'm on solid ground with my observation of the property last Thursday. I'm happy to hear that there's been progress made in the last 4 days. I take you at your word that you will complete remediating the property. Nevertheless, I'm going to approve the 180-day open abatement contained in application CE 191569.
Okay.
Thank you.
Can the city request a different inspector be placed on my property since this inspector has been trespassed from the property and not allowed on it?
What do you mean been trespassed?
I mean,
believe
he
they have the
committed a
authority.
crime on the property and received a civil trespass from the property where he is no longer allowed on it
Okay,
by law.
I'll have Mr. Tamulevich speak to that. Jeff. Okay. Thank you for coming. Good luck. I hope you clean the property as you indicate that you plan on doing. Our hearing is adjourned. Oh, I'm sorry. I do need to make an announcement that the next hearing will be on September 3rd, 2019. Thank you.